like to introduce our speakers, and I'd like to thank our speakers for coming along. First up, we're going to have Evie Nevin. Evie Nevin is from Disabled People Together for Yes. Evie has travelled to us from Cork, so we're absolutely delighted she's been able to make it to us this evening. And then we're going to have Catherine Murphy. As you all know, Catherine Murphy is a TD for the Social Democrats in Kildare North. And Catherine was also on the Joint Oireachtas Committee to repeal the Evie. So Catherine has a wealth of knowledge and information on this subject, and we're very thankful to Catherine. This meeting, of course, is co-hosted with the Social Democrats. I should mention that. It's Kildare Together for Yes, co-hosted with the Social Democrats, and we're very thankful to the Social Democrats for facilitating this meeting with us. We have Paula Morrin, or you might know her as Polly Molotov. Yeah, amazing. Polly is from Midwives for Choice.
Good evening, everyone, and I'd like to thank the group for inviting me to speak here tonight. And indeed, it is a lovely venue. I was fortunate enough to have been a member of the All-Party Oireachtas Committee on the 8th Amendment. And we had a great number of experts in the medical, the legal, human rights areas, and I think it made it easier for us to make a decision and to deliver a report. Some of the documentation, or most of it, is still online, and some of it is well worthwhile downloading and reading, because there were some very eminent people who came to speak to us. As we all know, the 8th Amendment was inserted into the Constitution by referendum in 1983, and that acknowledges the right to life of the unborn with due regard for the equal right to life of the mother. I didn't vote for that. I made it very clear when I was going on the committee. I didn't think that was a good idea in 1983 to insert something like this into the Constitution. Essentially, I think it has proved to be very, very problematic, and even more than people would have anticipated. After the 8th Amendment, of course, we had the 12th, 13th and 14th Amendments, which all were held on the same day, and they were all linked. They followed the X case where a 14-year-old girl found herself pregnant, and there was a doubt about whether she could travel, and I won't go into that in detail. But there were 3 separate but linked referendums in '92. The first one sought to exclude suicide as a grounds for abortion. This obviously followed the X case. This amendment was lost, and the outcome was very decisive. It was a 2/3 majority that rejected that amendment. The 13th Amendment permitted travel to obtain an abortion in another jurisdiction. This was carried by roughly 2/3 yet again, so it was a very decisive result. The 14th Amendment permitted information about abortion to be provided in other jurisdictions. So it wasn't just about a right to travel and a right to information, it was a right to travel and information in a very specific context. That referendum was approved by 60 to 40, so again, a very clear result on that. In a statement to the committee that I sat on, Dr. Peter Boylan outlined the current position as follows. Currently, termination of pregnancy on grounds other than a risk to the life of the woman is subject to criminal prosecution with a penalty of imprisonment of up to 14 years for the woman and her doctor. While simultaneously, the 13th Amendment provides constitutional protection for women to travel to obtain a termination outside the state, and the 14th Amendment protects the right for access to information to achieve this. He described the situation as profoundly hypocritical. Our Constitution enshrines a woman's right to commit an act which is a criminal offence in our own country as long as it's committed outside of the state. And he said, by any yardstick, that is a bizarre situation. There was a further amendment, the 25th Amendment, which was put in 2002. The referendum sought to insert legislation into the Constitution where there was a threat to the life, but not where there was a risk of a threat through suicide. The legislation was to allow for termination of pregnancy by a doctor at an approved centre where, in the reasonable opinion of the doctor, it is necessary to prevent the real and substantial risk to the loss of the woman's life. However, the risk of suicide did not qualify as a grounds for abortion, as I said. This referendum was very narrowly defeated, and the reason for the defeat was both sides objected to it. People felt that it was actually further containing a situation that they'd already spoken on by way of referendum, and people on the pro-life side felt that it was introducing abortion. So that's why that was defeated. So 2018 we'll be seeing the 36th Amendment to the Constitution. That should be at the end of May, and the reason why the date hasn't been announced yet is that you can't presume that it will be passed by either of the Houses of the Oireachtas, and it still has to make its way through the Seanad, but we are expecting that it will be the 25th of May, and I think that's reasonably certain. So should the referendum be carried, the Oireachtas will then be permitted to legislate. An outline of the legislation has been announced. It was a scheme, and then the Cabinet will see the wording of the legislation tomorrow, and we should see that either later this week or next week. But we have been told repeatedly by the Minister for Health that it will be along the lines recommended by the All-Party Oireachtas Committee, so we're not expecting it to be terribly different from that. We've been through a very robust process at this stage. First of all, we had the Citizens' Assembly, who listened to a wide range of experts, to individuals and to advocacy groups on both sides of the argument. And they produced a report with 13 recommendations. That report was presented to the Oireachtas, and then the All-Party Committee was formed. And essentially the work we were asked to do was to consider the report of the Citizens' Assembly, each of the individual recommendations. So we organised ourselves in a number of modules because we were given quite a sufficient time, but a short enough time. We had to deliberate and conclude before Christmas. So module one of our work considered the constitutional arguments. The Oireachtas Committee had recommended simple repeal of the 8th Amendment, while the Citizens' Assembly had looked for the exclusive authority of the Oireachtas to legislate. The government came up with a third set of words, and that really captured what both of us were trying to say, so it was a happy medium, and I think that most of us would be happy with the wording that's been proposed. Now, we needed to do that piece of work first because there's no way we're going to be able to legislate unless the 8th Amendment is removed from the Constitution. You simply wouldn't be permitted to legislate. So then we considered the issues that we needed to legislate on. The risk to life and health, and what was recommended was that the committee is of the view that no differentiation should be made between the life and health of the woman. This is consistent with the evidence from medical experts made available to the committee regarding the difficulty medical practitioners have in defining where the threat to health becomes a threat to life. And they did say to us, like, is it that at 20%? Is that at 50%? Is that at 90%? Where do they intervene? We're asking them to do the impossible. Dr. Peter Boylan said, serious risk to the physical or mental health of the woman overlaps with a threat to the life of the mother insofar as a risk to health may develop into a risk to life. Under current legislation, doctors have to make a judgment call as to when the risk to health becomes a risk to life. If the judgment is wrong, either the mother will die or the doctor will be guilty of committing a criminal offence. That's the backdrop that our medical professionals are dealing in. He went on to say, the risk to health of the mother, either physical or mental, raises the important question of how different people deal with risk. Some women, because perhaps of a longed for first baby, are willing to accept any risk in order to have a baby, while others, perhaps those with small children at home, the deterioration in their health represents an unacceptable risk. In these complex circumstances, he states, a decision to terminate is best left to a woman and her doctor. The committee agreed with that, and I very strongly agree with that myself. We then considered the issue of pregnancy that resulted from rape or another sexual assault. We heard a lot of evidence on this aspect. The length of time it takes to prosecute and secure a conviction, for example, is somewhere in the region of 2.5 years, and that's cases that go to court. The burden of proof in the absence of a prosecution, how do you decide that? We heard the Rape Crisis Centre and how prevalent non-reporting of rape is. We also heard that, re-victimising a woman or a girl who has been raped only compounds that. So it was decided that we should go a more compassionate route. So we recommended that, in view of the complexities inherent in legislation for the termination of pregnancy for reasons of rape, the committee is of the opinion that it would be more appropriate to deal with the issue by permitting termination of pregnancy with no restriction, as the reason provided, that is availed of through a GP-led service delivered in a clinical context as determined by law, and a licensing practice in Ireland with a gestational limit of 12 weeks. Dr. Boylan again said that there is no diagnostic test to confirm rape. So he strongly recommended that a woman who had undergone the trauma of rape should not be forced to prove a rape if she chooses to terminate the resulting pregnancy. Women should be taken at their word. And we were asked to trust women. And I think that is something you're going to hear quite a bit in this campaign. We're asking to trust women. We then went on to fetal abnormalities, or an abnormality that's incompatible with life. The committee, again, the recommendation was the committee recommends that it shall be lawful to terminate a pregnancy without gestational limits where the unborn child has a fetal abnormality that is likely to result in death before or shortly after birth. To force a woman to continue with a pregnancy to term when there is no prospect of giving birth to a live baby is really quite barbaric, in my opinion. Of course, if a woman decides that she wishes to continue to term with a pregnancy with that diagnosis, she should be supported in every way that it is possible to support her. For most women and couples who find themselves in this unfortunate situation, it will have followed the great joy of being told about the pregnancy. They will have looked forward with great hope to the birth of a live and healthy baby. They will have considered names, they will have shared the news with their family and friends, and they will be asked, is it a boy or a girl? It would be the normal kind of things that you'd expect. And then they get the devastating news, usually when they're around 20 weeks when there's an anomaly scan. And that's if you're in some parts of the country, because anomaly scans are not provided everywhere. And there's an inequality of healthcare in this country as well for women that are pregnant. So I I visited the Liverpool Women's Hospital myself in advance of the Protection of Life and Pregnancy legislation that was passed a few years ago, with a group that specifically around this issue. And the one thing I would honestly say was the compassion and care that women were treated with in that hospital really made me feel very shameful that they had to go to another jurisdiction to find that compassion and that care in this really, really terrible, sad time for them. And it was really quite instructive. The other grounds then were the socio-economic grounds, or the grounds with no restriction. And I once again would quote Dr. Peter Boyle, who says, "The genie is out of the bottle in respect of online access to the abortion pill. The grave concern that we doctors have as a consequence of this reality is the potential for harm caused by the use of unregulated medication by Irish women and girls. I believe it is a matter of priority for the Oireachtas to address the reality of this situation. The problem is the Oireachtas can't without the instruction from the people, and the instruction from the people to allow for that would be to remove the 8th Amendment from the Constitution. The committee recommended that the law should be amended to permit termination of pregnancy with no restriction as to reason, provided that it is availed of through a GP-led service delivered in a clinical context as determined by law and licensing practice in Ireland, with a gestational limit of 12 weeks. The Citizens' Assembly didn't consider in any significant detail the prevalence of the abortion pill. The Oireachtas Committee met Miss Justice Lafoy, who chaired the Citizens' Assembly, and we asked her about what was deficient in terms of what did they not really get to deal with, and this was one of the issues she asked us to pay particular attention to, because they hadn't considered it in the detail that she thought they should. The availability of the abortion pill has changed matters considerably. Most of the committee were concerned about the risk posed in relation to the lack of medical supervision. As I said earlier, amendments to the Constitution with respect to right to travel, to procure an abortion, the right to information about services in other countries mean that most abortions occur legally, but legally in another jurisdiction. Prior to the UK's 1967 Abortion Act, there were backstreet abortions. They were unregulated. They happened. It was much more dangerous, but it happened. The vast majority of terminations in the UK occur before 9 weeks. Women given an Irish address tend to have abortions that are slightly later. And that's not that's not good. The earlier it happens, the better. It is not about abortion being prevented. In actual fact, when we looked at, if we looked at the Dutch situation, and we had medics and legal people over from Holland, and it was very helpful in our deliberation. They managed to regulate abortion and reduce the rate of abortion. They did this by delivering comprehensive and age-appropriate sex education as a central piece to their strategy. They delivered adequate counselling and good follow-through on birth control. That's how they reduced the number of abortions, and at the same time they legislated and created a regime around abortion in the context of their healthcare. The All-Party Oireachtas Committee, and indeed the Citizens' Assembly reports, had these as ancillary recommendations, but we made sure they went in, and we made sure to highlight the importance of this approach, and I think government have heard what we were trying to say on that. They were very central to the strategy to provide abortion services in a highly regulated medical environment where there is improved health services, and there needs to be improved health services, and there needs to be an equality of healthcare. Abortion should be as rare as possible, but each each woman that embarks on that trip or has an abortion doesn't do so lightly, and I believe we should trust women. So what happens if the citizens reject the referendum? If the 36th amendment to the Constitution is rejected, we have a status quo. The right to life between women and the unborn will remain equal and constitutionally protected. That means legislation will not be permitted outside of very, very strict criteria, the criteria that we have at the moment. The sanctions of up to 14 years in prison contained in the protection of life during pregnancy will continue, and that will be the backdrop for healthcare for women in Ireland. Pregnant women will not have a right to health and will not have a right to consent to their pregnancy and delivery care. They don't have that at the moment. You don't get a form to fill in to sign consent. It's governed by law. We will see continued legal challenges in the European Court of Human Rights, where the right to health, for example, cannot be vindicated for pregnant women. Those facing the tragic news that a much wanted baby has a condition that's incompatible with life will continue to travel or will require to continue with the pregnancy to full term in Ireland. And we can see in the British situation there only recently, some of the services were closed to Irish women because there's a capacity issue, and that is likely only to get worse. So if it's rejected, thousands of women and girls will continue to travel to seek care in other jurisdictions like the UK or Holland. Women will continue to self-medicate in increasing numbers with the inevitable consequences of over-medicating or maybe having an underlying health condition that will lead to serious health issues or indeed even deaths. Abortion is a deeply personal decision that is never made lightly. It's an issue that should be decided between a woman and her doctor within a regulated environment. I believe as a country we have a collective responsibility in this. We'll get that opportunity, I believe and I hope, on the 25th of May. The 8th Amendment requires to be replaced. I hope the 25th of May will be remembered as the day we came together and we voted together for yes. Thank you.
Good evening, everybody. My name is Paula, and tonight I'm here representing Midwives for Choice. I'm a midwife in a maternity hospital in Dublin. I'm also a registered general nurse, and I'm a neonatal intensive care nurse. I'm also a mother, a grandmother. I have suffered through a crisis pregnancy myself. It's interesting to me that the 8th Amendment came in 1983, and Lovett died in 1984. Given birth to her son, who was named Pat posthumously. Her sister Patricia died by suicide 3 months later. 7 years later, in 1991, I was 15 and I concealed my pregnancy for 5.5 months. I gave birth to my eldest daughter, who's now almost 27. Baby Maria was found at the side of a road in Raccoon in 2015, so really not much has changed. But tonight I'm here to discuss the 8th Amendment from the aspect of human rights in pregnancy, labour and delivery. Bear with me, I'm not used to speaking in public. The impact of the 8th Amendment on all aspects of maternity care in Ireland. This Article 40.3.3 of the Irish Constitution, it enshrines the equal right to life of the woman and the fetus. In practice, however, this has meant that the fetus takes preference. The impact of the 8th Amendment, beyond restricting abortion rights, is substantial and far-reaching. It affects the fundamental human rights of every woman in pregnancy and childbirth, denying her rights to bodily autonomy and informed decision-making in relation to medical care and treatment. that are recognised in every other aspect of her life. Arguably, in voting for the 8th Amendment in 1983, the people understood that they were voting about abortion only. And I know my 70-year-old aunt said to me recently, having heard the story of Geraldine, who was brought to court in an attempt to force her to have a C-section, my aunt and my mother, who would be very Catholic, very Christian people, they both exclaimed, we didn't vote for that. They thought it was abortion only. The language of the 8th Amendment itself, which refers to the life of the unborn, has been interpreted to bring the duration of pregnancy, labour and birth within the amendment's reach. The 8th Amendment directly impacts on the right to choice in childbirth of some 60 to 70,000 women giving birth annually in Ireland. The National Consent Policy states that the consent of a pregnant woman is required for all health and social care interventions. However, because of the constitutional provisions of the right to life of the unborn, Article 40.3.3 of the Constitution of Ireland 1937, there is significant legal uncertainty regarding the extent of a pregnant woman's right to refuse treatment in circumstances in which the refusal would put the life of a viable fetus at serious risk. In such circumstances, legal advice should be sought as to whether an application to the High Court is necessary. This has serious implications on all healthcare professionals. Unsafe abortion is one of the 5 leading causes of maternal mortality globally. Midwives for Choice supports repeal of the 8th Amendment and the liberalisation of Ireland's abortion law in the interest of safeguarding the lives and health of women living in Ireland who choose abortion. However, I'm now going to focus more on the human rights elements. But regardless as to healthcare professionals' own beliefs, we are duty-bound to care for the population entire. And currently, our hands are tied due to the 8th Amendment. We are unable to care for all of the people of this country. This does not lead to job satisfaction by any means. It leads to upset, to anger. It leads to exclusion. We need to include everyone on all pregnancies, regardless as to whether they are crisis, wanted, continuing or not. The 8th Amendment impacts so many women every single year. I do include everybody, women, girls, all people who are pregnant. It substantially erodes our right to bodily autonomy. Bodily autonomy is key to a human rights framework for healthcare. It allows us to make decisions about what is best for our own well-being, based on information provided by our healthcare providers. For midwives, it allows us to do our job. Midwifery, well actually the word midwife means with woman. That's all it means. We are there to assist her, to inform her, to advocate for her, for the good of her and for the good of her baby. Our human rights are enshrined under the European Convention of Human Rights. Ireland has obligations here that it is not currently fulfilling, and it cannot fulfil as long as the 8th Amendment prevails. A human rights framework allows for dignity, respect and safety to be delivered to every patient, and importantly allows for legal recourse in the event that this does not happen. In pregnancy, it includes all women and seeks to accommodate all choices. Those who do go into hospital, those who are turning away from hospital-based services or obstetric-based services, e.g. home births, midwifery-led units or birth centres. Unbelievably, in 2018, we have 2 MLUs, midwifery-led units here in this country, and we have no birth centres. Home births, there wouldn't be very many of either, so really choice, there isn't a whole lot of it. This compares very poorly to our European neighbours. Human rights in pregnancy and birth cannot be framed solely in terms of access to care. It must also take into account quality of care. We are often told Ireland is one of the safest places in the world to give birth, but this is based on mortality alone. It is not based on provision of quality services. In a human rights framework, it's is simply not enough. A woman cannot be told that regardless of her birth experience, the only thing that really matters is that she and her baby are alive. And we hear this all the time. Isn't it great? Sure, aren't you grand? Isn't your baby alive? Not taking into account that this person may be at the most traumatised they have ever been in their lives. It's not an appropriate thing to say. It's not an appropriate thing to assume. A human rights framework for pregnancy and birth means that the risk of a woman being seen as a means to an end is averted. She remains an end in herself, not a means to the production of her baby, whose interests can be subordinate of the needs of the fetus. For human rights to prevail, it is based on the idea of respect for the decision a person takes. Because only upon respecting each other's free will can we respect one another as human beings. The consequence is that in pregnancy and birth, as in elsewhere, you must respect the woman's decisions. It's a time when women, people, need to be supported, not opposed. It takes very little to crush the fragile self-confidence that we need in order to approach labour without fear. Why does it matter? Research has shown time and again that the two things that really matter in birth are a supportive, respectful relationship with midwife or doctor, a sense of control. This does not mean that things can't deviate from a plan. It means that the person has been consulted and continue to be a decision maker in their care as events may unfold. In Ireland, there's a historical sense of silence regarding birth, so as not to frighten other people. We need to talk about our experiences. We need families to discuss their experiences. We need to educate each other. We need to share knowledge and build self-belief. We need to empower each other. Human rights law. There are numerous charters and conventions expressing human rights in healthcare, including the World Health Organization, Amnesty International and the United Nations. However, the European Convention, which invokes a woman's right to respectful care, is as follows. Article 3, no one should be subjected to inhumane or degrading treatment. I think anybody that has gone into any maternity hospital, historically and presently, will have their own stories of what that statement means to them. How might this bear out in the maternity care situation in Ireland? In the area of compliance, how it is created, including through coercion, disrespectful care, bullying, abuse, or in extreme circumstances, the threat of court. My sister couldn't believe recently when I told her that if she was a patient of mine, I had the right to expose her to circumstances that she may not necessarily agree with or want to happen to her, and that if she disagreed, it was well within my rights to ring the guards or to bring in a solicitor. My sister is a year older than me and genuinely couldn't believe this. Not that I would do that to people, but I have the right to do it as a midwife. Examples of bullying and coercion are being told consent is not needed for a medical procedure. In my experience as both a nurse and as a midwife, there's always time to ask for consent. There is always a moment, even in an emergency situation. There's always a moment to explain. Emergencies do happen, and things do need to happen. But explaining can just make all the difference between a traumatic horror story of a birth and one where the woman feels fully informed and appreciated. Fear or guilt being used to create compliance over informed consent. Here we have active management of labour. Maternity hospitals are very, very busy. Conveyor belts, really. So when we're in college, we're all about the woman and giving them lots of time. And then we go out and we get our jobs in the maternity hospitals and we soon realise, oh, this isn't the way I was taught. Active management of labour is to speed up the process. Women over 40, for example, will be induced. I don't know if anybody would know the word ARM, if that means anything to anybody, but it is artificial rupture of the membranes, and the membranes are the sac of fluid surrounding the baby. We can coerce people into allowing us to do that, to speed up their through labour, but it has also been done to people without their consent. And what that involves, dramatically, is, for example, if I were to do it, I would have to insert my hand into somebody's vagina, insert a hook alongside my hand, and artificially rupture their membranes. To have that done to you without consent being given is a massive violation. There's plenty of examples. The EU Court has stated that Article 8, which outlines a woman's right to a private life, in a broad sense means physical autonomy and integrity. Childbirth rights feed into this. Instances where a person's right to a private life might be violated in maternity care: physical abuse, e.g. episiotomy. I don't know if anybody's ever been told, we're just giving you a little cut. That's an episiotomy. So unless you're asked, do you consent to an episiotomy, you haven't given informed consent. And I have so many people that approach me with stories about this. They say, no, I didn't have an episiotomy, just had a little cut. And they're horrified, and they know the truth. There's also massive disrespect to threats, being told your baby will die. Your baby might die if you don't let us do this. Being bullied or coerced into consent is not consent. For appropriate consent, one must be fully informed. Other examples of violations are non-confidential care, non-consented care, and misinformed care. Depersonalised care. Hospital policies, for example, one size does not fit all. I've yet to meet two people with the exact same experience in childbirth, pregnancy, delivery. Discriminatory care. For example, as I mentioned, women over 40, oh, you must be induced. Abandonment of care, and this does happen here. You make a choice out of the system and you're told, we're abandoning you now. You put a mother's life at risk. There was a case of this in Ireland where a home birth woman refused a hospital transfer and was left to birth alone. The midwife was not allowed by order of the HSE to continue her care, or she risked her licence to practice. The midwife had to stay outside the house and could only re-enter after the baby was delivered. So how do human rights improve maternity care? They give practical effect to women-centred care. They create personalised care, not based on institutional policies. Decisions must be respected and reported. Respect, kindness and compassion prevail. No stigma can be applied for specific vulnerabilities. No discrimination can prevail. Human rights have legal teeth. Obligation to state can be enforced in court. It's not our position to judge anybody we care for. It is our job to care. Women's autonomy in the 8th Amendment. Interestingly, unlike abortion, which must be legislated for, if the 8th Amendment was gone tomorrow, an environment where a human rights framework for maternity care can apply immediately opens up. This is not to say that there aren't barriers. We must consider a broad maternity culture that in its very fabric contains institutional, we must consider a broad maternity culture that is inclusive. Active management is a barrier to our maternity rights in this country. As I said, one size does not fit all, and the conveyor belt system is not appropriate. In the UK, they have an entirely different system. I worked up in Lisburn. I delivered 2 babies up there, and the women were 18 and 23. And the first woman was the 18-year-old, and it was a midwife-led unit. She believed in herself. She didn't want any intervention. She didn't get any intervention. She delivered at 8:30. The morning was gone home at 4. She had no terror. She had no episiotomy. They had been raised with self-belief. They were empowered. And the system we have here, we have a very patriarchal system here, where the masters of the hospitals up until very recently were men. We have 2 female masters now. So we are very obstetric-led here, and this needs to change. In the UK, if mental capacity is not an issue, you can make a choice in pregnancy and childbirth without being forced into medical intervention by court. The fetus does not have a separate legal personality. In Ireland, the state acknowledges the right to life of the unborn, and with due regard to the equal right of the life of the mother, guarantees in its laws to respect and, as far as practical, to defend and vindicate that right. When a pregnant woman in Ireland makes an informed refusal to treatment recommended by her medical team, and there are perceived implications for the life or health of her unborn baby, the National Maternity Strategy and the National Consent Policy state that, under the 8th Amendment, legal advice should be sought. As a result of this policy, the High Court has been asked to intervene in a number of cases in which women have made medical decisions in late pregnancies, which their doctors argued place their unborn baby's life or health at risk. We know of the case of Miss Y and then the case of Miss B, where in Miss B's case, the fetus was represented separately in court from the mother. The HSE versus Miss B made clear that the woman cannot be compelled to accept medical treatment in their unborn baby's interest where the risks to the unborn from refusal are low and the proposed treatment is very invasive. However, it does not clarify precisely when women can be compelled to accept treatment short of surgery, or exactly how high the risk to the baby must be before serious unwanted medical or other state interventions can be justified. This lack of clarity generates serious difficulties for women in negotiating the maternity care. Therefore, the 8th Amendment is not first and foremost about abortion. It is about creating a second class of citizens, pregnant women, pregnant people, and subjecting them to state intrusion in the way that no man would ever be subjected to. The implications are profound. The 8th Amendment is about apartheid. Once you are pregnant, the state has regard to the right of life, to the right of life of the unborn. From the moment of conception, you are a different class of person in Ireland. Pregnant women are subject to a different form of state intervention in continued pregnancy, just as in abortion. As a nation, we are slowly learning what these are for abortion, but we remain blissfully ignorant of what they are in continued pregnancy. As we have said, forced medical intervention, fetal right to life empowers medical staff to override a woman's informed choices by a court. This is pretty serious. It's pretty frightening. Other interventions are post-dates induction, where a woman's knowledge of dates is disregarded and she's compelled to be induced even if she does not wish or agree with the assessment of date. I have already discussed episiotomy there. Testimony from women surveyed both by AIMS Ireland and Midwives for Choice clearly shows that women are coerced, threatened or bullied into compliance. They have no legal recourse under the 8th Amendment. The Hamilton case. Ciara Hamilton had her waters broken without her permission and without her knowledge. She suffered a cord prolapse, and what that means is the umbilical cord prolapsed out of her womb down into her vagina. It caused extreme danger to her baby. Her baby was compromised. She had expressly asked for her waters not to be ruptured, for her membranes not to be ruptured. Ciara took the case to court. She lost and also had damages against her for attempting to invoke her human rights through the Irish courts. She lost big. Her baby ended up in NICU. Today I read a press article, I'm not certain if it was the Irish Times, where it was suggested for unwanted pregnancies, deliver them early. We are not vessels, we're not incubators. Impact of the independent obligation to the fetus on the healthcare provider. This impacts us as midwives. It stops us from doing our job of being with all women. It is a scary position to be in. It's an environment where responsibility of control is in the hands of the HCP, healthcare professionals. Is it any surprise that problems arise? It is a power not warranted, and nor should it be wanted. It can lead to an environment of fear. This immediately diminishes when the authority and responsibility is given where it rightly belongs, to the woman, in an informed setting. The threat of litigation evaporates with it. So just to recap, the 8th Amendment means that a human rights framework based on dignity, respect and safety is not available to the 60 to 70,000 women of Ireland who give birth each year. Instead, she is a second-class citizen. Irish society rightfully attaches a high value to motherhood and recognises the intense vulnerability of women during this time. Any interpersonal care that is disrespectful and abusive in nature to women before, during and after birth is an infringement of a woman's right to respect, dignity and choice that extends from a human rights framework. All childbearing people need and deserve respectful care and protection of their autonomy and right to self-determination. This includes special care to protect the mother and baby, as well as marginalised or highly vulnerable women such as adolescents, ethnic minorities, women living with physical and or mental disabilities. Most importantly, as the respondents to the AIM survey bear out, disrespectful care is an infringement of women's human rights to non-discrimination, liberty and security of the person. Reproductive health and autonomy and freedom from cruel, inhumane and degrading treatment. Vindicating these rights means that women cannot be subjected to medical treatment without their full, free and informed consent. It also means respecting competent pregnant women's medical decisions, even where they conflict with medical advice. Any forced intervention or treatment on a pregnant woman who has made an informed decision that the associated risks outweigh the benefits for her and her baby is an intolerable act. But forced intervention that takes place in a setting where women hold less power than doctors, in a society where women's capacity for pregnancy has been historically used to sanction their exclusion from full citizenship, is more than a simple battery. It is a form of gender-based violence, increasingly recognised around the world as obstetric violence. The articulation of obstetric violence in legislation, specifically within the ambit of women's human rights to health, equality and freedom from violence, shows an understanding of the causes and consequences of abuses in childbirth that far exceeds that in Ireland to date. The work of eliminating gender-based violence in Irish maternity care must include legal frameworks that invoke state and institutional responsibility for ensuring respectful care at birth. Repeal of the 8th Amendment is a necessary and critical first step to enable that work to begin. Article 40.3.3 must be removed completely from the Constitution in order to respect the lives, health and choices of pregnant women, and there must be no replacement, since any restriction will render the current position unchanged for women in continued pregnancy. We as healthcare providers need to be allowed to care for the population entire. We need to vote yes for better pregnancy, vote yes for better healthcare, vote yes for better birth.